You get a concurrence. Hello? தம்பி சொல்லுப்பா. லைவ் ஆயிடுச்சிங்களா? சரிப்பா சரிப்பா. ஓகே ஓகே. You get a concurrence. ஹலோ தம்பி சொல்லுப்பா. லைவ் ஆயிடுச்சிங்களா? ஹலோ மேடம், குட் மார்னிங் மேடம். Madam, we are about to start webinar, madam. Can you join, please, madam? Please. Okay, madam. Okay. Thank you, madam. Thank you, madam. Okay, madam. Okay. Thank you, madam. Hello. தம்பி சொல்லுப்பா. லைவ் ஆயிடுச்சிங்களா? ஹலோ மேடம், குட் மார்னிங் மேடம். Madam, we are about to start webinar, madam. Can you join, please, madam? Yes, we can start, madam. Okay, madam. Okay. Thank you, madam. Thank you, madam. Okay, madam. Okay. Thank you, madam. Hello. தம்பி சொல்லுப்பா.
Shall I start, sir?
Live ஆயிடுச்சிங்களா? Yes, ma'am, we can start. Madam, good morning, madam.
Good morning, everyone.
Madam, we are about
Thank
to
you.
start webinar,
Thank you
madam.
all
Can you
for
join,
finding
please, madam?
time for joining us for today's
Yes, we
webinar,
can start, madam.
National Level
Okay.
Webinar.
Okay.
Welcome,
Thank you.
everyone. I, Vibhisha Rani, final year MCom from Sri Bhagawan Mahaveer Jain College. A very warm welcome to all. It's a wonderful day, and I feel privileged to extend my warm welcome to all present here. The capacity to learn is a gift. The ability to learn is a skill. The willingness to learn is a choice. Welcome everyone to the national level webinar on Introduction to Intellectual Property Rights, organized by our PG Department of Commerce. Now, without further time, I would like to call Shushmita from first year for welcome speech.
Not audible. Susmita, not audible. Not audible. Please start from the beginning.
Good morning. Greetings to one and all present here. I deem it a pleasure this wonderful morning to deliver the welcome address. This beautiful day has dawned and brought us to the most awaited event, National Level Webinar on Introduction to Intellectual Property Rights. The vision and mission of our chairman, Dr. Chendraj Raichan Jain, is to ensure quality education not only in our town but also to cater to the needs of our neighboring places as well. We extend a warm welcome to our Managing Trustee, Sri Mahendraji Munot, who is always ready to meet our intellectual requirements and a great support to us. We welcome you, sir. I heartily welcome our Honorable Chief Guest, Dr. S. Ganesan, Associate Professor and Head Department of Economics and Center of Research at Ayanadar Janaki Ammal College, Sivagar. We welcome you, sir. Here is the time to extend my hearty welcome to our lucky charm and a dynamic powerhouse, our beloved principal, Dr. Rekha Shetty, ever young, charming, smiling, and an advocate of peace. We welcome you, ma'am. I would like to welcome Dr. J. Anthony Sangarat, HOD of PG Department of Commerce, the backbone of our PG department. We welcome you, sir. I would like to welcome our organizing committee faculty, Mr. Tony Lazarus Prem Kumar, Mr. Murli Kumar, and Mistress Radha. I would like to welcome our coordinating faculty members, Mr. Sidra, Mr. Hari, Ms. Shamla, Ms. Gladius Lydia R. of SBMJC, the ever-inspiring place in this town for development. A big welcome to all the participants who had taken time in participating in the webinar. Thank you all for spending your valuable time in attending the webinar. I wish this session gives you a lot of knowledge about the topic and useful information. Once again, I welcome each and everyone. Thank you.
Thank you, Shushmita. Now I would like to invite our Honorable Principal Ma'am, Dr. Rekha Sethi, to speak few words about this webinar.
Dear students, today Madam is about to attend a university meeting. Madam is on the way to university, unable to give her felicitation address. But when I called Madam, Madam said to convey regards and appreciations on behalf of her. So I convey Madam's regards and wishes on behalf of Madam to all the participants. Okay, thank you.
Now I would like to invite our Head of PG Department, Dr. Anthony Cruz Tangaraj, to address the gathering.
Very good morning to all the participants. Respected Secretary of the institution, Sri Mahendra Kumar Manojji, respected Principal of the institution, Dr. Rekha Sethi, respected resource person of the Dr. S. Ganesan, Associate Professor, Department of Economics and Center for Research, INRR Janaki Ammal College, Sivagasi. Dear teaching faculty members and teaching fraternities who are attending this webinar, and my dear students and other participants, very good morning to all of you. Now, it gives me an immense pleasure in inviting all of you for this national webinar on the Intellectual Property Rights Act. Now, an introduction to Intellectual Property Rights Act. See, when we talk about now this intellectual property rights, intellectual property rights, which deals with the seven main components. Now, one is copyright, and which comes under Copyrights Act 1957, and patents comes under Patents Act 1970, and trademarks and the Trademarks Act 1999. And apart from that, business secrets, industrial designs, geographical indications, trade dress, and these are the seven major components which falls under intellectual property rights. And these are being managed and monitored by the IPR Act in India as per the Indian Code of Conduct. Now, why we need to have this IPR? Now, what is the need to have a discussion or to acquire knowledge about this IPR? So mainly for or from mainly for acquiring knowledges about imitations, and also some inventions, and some precious contributions are being copycated. Now those kind of imitations and copycatings, and for preserving the inventions made by the skilled people and by the elite people, and for earning profit. So when we speak about business secrets, and when we talk about industrial designs, and when we talk about geographical indices, now it is exclusively related to trade and trade-oriented aspects and trade-oriented aspects of inventions, where we have more possibility of earning profit. So therefore, this IPR need to be preserved even for profit and for the benefit of the society. So inventions need to be benefited to the society in such a way it is going to give more benefit rather than disadvantages. See, for example, when certain inventions which are invented with the intention of providing a good to the society, but it also, when it is misused, now that is going to harm the society. So when it is the case, now that kind of technological innovations so need to be preserved. So under such circumstances, now this IPR is really very much useful to preserve and to obtain and obtain from and obtain the uses and to obtain the uses exclusively from the IPR, from the inventions. Now this IPR is used. So like this now for so many benefits. Now this intellectual property rights are widely used all over the world. But no, today's topic exclusively throws enlightenment on Intellectual Property Rights Act, which is followed in India. And also, see, at this juncture, I would like to invite a professor, Dr. S.M. Krishnan, who is associate professor and head of Government Arts College, Krishnagiri. He is attending so right now our webinar. I also welcome professor at this moment for this IPR webinar. So with this, now I welcome and I feel really privileged at this juncture in inviting the all the participants, and I hope that now this webinar would provide a benefit to all the participants. Thank you, one and all. Thank you very much.
Thank you so much, sir. Now I would like to call Maithili from final year to introduce the resource person for this webinar.
Good morning, everyone. I, Maithili from final year MCOM in SBMJC. Before I take the pleasure of introducing our guest speaker, please allow me to express my gratitude to our dear principal, Dr. Rekha Sethi, to our convener, the head of the PG department, Dr. Anthony Cruz Tangaraj, for planning this webinar. It gives me an immense pleasure to introduce and welcome today's resource person, Honorable Dr. S. Ganesan Sir. Sir is working as an associate professor and head Department of Economics and Center for Research in Ayya Nadar Janaki Ammal College Autonomous Sivagasi. He completed MA, MPhil, B.Ed and the PhD in the Madurai Kamaraj University with the title Energy Consumption Pattern of Small Scale Industry in Virudhunagar district in 2007. Sir has 18 years of teaching experience till date. Sir has received and completed 3 major research projects in his experience and collaborated with State Planning Commission and district and block authorities, where he has been as a resource person and also conducted socio-economic survey. Sir is also now being a research guide for the candidates of PhD thesis. He published 12 research papers in international journal, of which 6 is Scopus indexed and other 6 in UGC listed, and also published 6 national journal and made his contribution in 14 edited books. Sir has also published 6 articles in Dinamalar daily. It's a Tamil daily in Parvai. Sir has presented 8 papers in international conference and 34 papers in national and state conference. He has been acted as chairperson in 2 different colleges and delivered guest lectures on various topics and been as an external expert and board of examiners for various institutions. Finally, the awards conferred to him are University NSS Best Program Officer Award by Madurai Kamaraj University in the year 2008 and 9, State Level Best NSS Program Officer awarded by Tamil Nadu State Government in the year 2009 and 10, Teacher of Moral Values awarded by Teni Kalai Ilakkiya Mandram, Teni in the year 2016. Various contribution to the institution and the society is made by him. It is indeed a great privilege to him with us for this national webinar. Thank you so much, sir, for accepting the proposal. A very warm and heartfelt welcome to you for today's session to insight us on the topic intellectual property rights. Thank you, sir.
Thank you so much, Maithili. Before moving ahead, I request all the participants to kindly mute your mic and camera. And if you have any question during the presentation, feel free to type it in chat box. Your active participation is important throughout the section. Without taking much time, I would like to invite our Dr. S. Gajakesan sir to start the section. Over to you, sir.
Thank you, madam. Am I audible?
Sir, yes, sir. You're audible, sir.
Okay. Good morning, everybody.
Good morning, sir.
It's my great pleasure to thank the management of Jain College, principal, and especially the organizer of this webinar, Dr. Anthony Cruz, who has chosen me to deliver a talk on intellectual property rights. And also, I would like to thank my colleague, Dr. Salwa Kumar, who referred my name to Anthony Cruz. So because of that only, now I am with you to share some of my ideas regarding intellectual property rights. So, and apart from that, I would like to thank the participants from Jain College and also from people from other colleges. So once again, I thank everyone who have given me a chance to deliver a talk on intellectual property rights in the August gathering. So now we enter into the topic. Sari has given, I think, 45 minutes to me to complete the session, right? So I try to finish the things within 45 minutes to 1 hour, not more than that. Exactly, I think I have planned to complete my talk before 12 o'clock. So I won't take much of your time. So whenever we talk about property, we think about the material property. How much amount of land we are having, how many acres of land we are having, how many buildings we are having, how much amount of money we are having in our hands. In these things only we think about when we pronounce the word property. But here we never thought about the property of an individual or the knowledge of an individual, that is called the intellectual property. So the recent past only, we people are having knowledge on the intellectual property and how we can use our intellectual property, how we can get a patent, copyright, and some other things. So intellectual property is a very important one. A person who is having knowledge on a particular subject or a particular area, he will be given importance nowadays. So we have to understand what intellectual properties which we have within us, that we have to understand, and we have to exhibit our talent in the form of any kind of intellectual properties, and it should be given, it should be get patent or copyright. Because we people are in the teaching line, we mostly use the copyright as our right. So whatever, suppose if you are writing a book, or you are writing an article, or you are writing a poem, or you are writing a verse, or whatever a thing that you are having in your mind, it would be in the form of a literature, it should be get a copyright, because after that only you can, the owner, you can take the ownership of that particular literature or other things. Otherwise, the idea will be used by somebody else and they can claim the rights. So don't give your intellectual to others to copy or misuse it. So this is the background around the webinar. So we people should have some awareness about intellectual property rights. So here, under intellectual property, we can share the word, or you can divide the word into two things. One is intellectual and another one is property. So here, an intellectual means an extraordinary ability of a person to think. Some people are having a rich knowledge on or rich thinking capacity. If any problem arises, they can think or they can give a solution in different ways. So that is the thinking capacity of an individual. How we can solve the problem? What is the cause? What is the effect? How we can rectify it? So in this way, some people, they have critically thinking. So you take into account of the people who are in the engineering field, they can create a new idea for a small problem. So then only it is possible by them to success or succeed in the particular field. So here we have to find reason. We have to find reason for the problems. Then we can understand why this problem arises and other things. So these things are comes under the intellectuals. And you take into account of property in economics and commerce, because we are all brothers and sisters. And here we think about wealth or property in the sense wealth. Wealth should be a movable or it may be an immovable one. If it is a movable one, we can move the property from one place to another place. If it is immovable, it is attached to the land. It's not possible for us to take from one place to another place. Next slide. Then you take into account of properties. Again, the property are divided into two things. One is tangible property and intangible properties. The tangible properties are, it is possible by the person to see and touch. For example, you take into account of a house. It's a tangible property. We can see, we can touch, right? But it is not movable from one place to another place. But you take into account of your machine, it's a tangible property. We can see and touch. If we want, we can move it from one place to another place. And you take into account of intangible properties. Now I am talking with you via online. It's an intangible property. I am sharing my knowledge. What knowledge I have gained. Now I am sharing my knowledge with you through this seminar or this webinar. So here it is not possible for you to see and touch. You are seeing my face and you are hearing my words, but the way I am teaching you or I am sharing my ideas, it's not possible for you to see and touch. It comes under here the trademarks, copyrights, patents, everything comes under the intangible properties. Are you clear about the properties? So movable and immovable, tangible and intangible properties. Then what is intellectual property? Now you can combine the words intellectual and property. Now what is intellectual property? So here intellectual property is nothing but creation of mind. Creation of mind. You can take into account of the artisans. The artisans who are making, suppose you take into account of your potter, a potter who is making pots. Each and every part, the artistical skill of the potter is included. So it is the creativity of his mind. What is having in his mind, that creativity will be displayed or exhibited in the form of a product or a form of a pot. You take into account of the museums, you can see the weapons which are used by our ancestors, right? The weapons, in what way they have designed the weapons. It is the artistical skill of the person who designed. So it is a creation of mind. And in so many ways, there are so many artisans, they are exhibiting their talents or what they are having in their mind in the form of a product. Many sculpture you can see. So suppose if you are a devotees of any religion, in the ideals we are having in the temples, it's an artistical skill of the person. So it is a creation of mind. So here invention comes under creation of mind. But we are having in our mind or in our brain, that will be given in a form of a product, that is called an invention. So new ideas, new products, new structures, new programs. So whatever the way you can take, it's called invention. Then industrial designs, the designs made by different types of industries in different products. The same product will be designed by different industries in different way. That is called the industrial design. Then you take into account of the literatures. Suppose an author who is writing a book, a poem, or a lyrics, a story, or if a student and the professors, if we are writing an article, right? All these things comes under the literature or literary work. Then artistic work, painting, new creation, making of toys. 2 days back in a news I have saw a 2-year-old child, he makes more than 36 pictures using different colors. So it is his creation. So if the child wants, she or he can take the rights of that particular picture. That comes under intellectual property rights. Then symbols, many symbols we are using. I am having slides for each and every things which I have given here, invention, industrial designs and other things. Then names and images. Your college Empalam, your college name, it also comes under the intellectual property, because what's the college emblem you are using is not used by any other educational institution. What emblem the Ayanadar Janayamal College is using, it is an unique emblem for Ayanadar Janayamal College. It is not possible by copy or not possible by others to use it. Next slide. So here invention. The picture you are seeing is Alexander Graham Bell, who introduced or who invented phone. So here there are so many inventions which are made by the people around the world. You take into account of electricity. It was invented in the year 1759 by Benjamin Franklin. Radio by Marconi in the year 1895, and the electrical bulbs by Thomas Alva Edison in the year 1879, and the aeroplane Wright brothers 1903, dynamic Alfred Nobel. So in the name of Alfred Nobel only the Nobel prizes for different subjects are given. So here dynamite was invented by Alfred Nobel in the year 1867. And you take into account of the mobile phone, it was invented by Martin Cooper in the year 1973. And the smartphones now we are using. Now we are, each and everyone we are having in our hand a smartphone. Now without smartphone, it is very difficult for you to participate the webinars and seminars like this. The smartphone is introduced by IBM in the year 1992, and the air conditioner which we are using in our home and offices is invented in the year 1902 by Willis Carrier. And the WWW, that is the World Wide Web, now we are all connected together, is invented by Tim Berners and Robert Cailliau in the year 1989. So in this way, we can quote many inventions which are made around the world. Some of the notable inventions made by our Indian people, the zero and the number system, 458 AD, invented by Aryabhatta. We are the person, the Indians, we are the person who introduced the number system and zero. Then the wireless communication, Sri Jagadish Chandra Bose in the year 1895. And you take into account of the rockets. Now we are launching rockets to the space, but it was invented in the year 1780 by Tipu Sultan. So these are all some of the inventions which were made by the Indian notable peoples. The next slide, industrial design. Now you are seeing a chair. It's a chair designed by one industry. We are using chairs to sit. Different models of chairs we are having. That means each and every industry, they want to make some changes on the product. Then only it is possible by the company to market its product in the market. Right? You are all commerce people, very well about the marketing techniques and other things. So in the present world, we have to make some differences in the product. Then only it is possible for us to get our product in the minds of the consumer. When our product should be entered in the minds of the consumer, at that time only we are taking the consumer towards purchasing our product, right? So here is an example I had given. There are so many ways the product. If the company is making this type of industrial design, immediately that company get patent for this design, because this type of design, the chair will not be used by any other company. If you are not getting a patent right, this design will be copied and used by some other company, and they will get patent, and the rights will be moved from you to somebody else. The next, you take into account of the literatures. Here, the epics. You take into account of epics, Ramayana, Mahabharata. You take into account of Tirukural. There are so many literatures our ancestors they have made until it is in life. And nowadays, in the recent people also, many writers, they are writing books, they are writing poems and other things. So everything will be comes under the literature area. Then you take into account of the artistic work. Next slide. Now this picture you are seeing is the Mona Lisa, the oil painting made by Leonardo da Vinci in the year 1503 to 1519. So it's a artistic work made by Vinci. Next, the symbols. So it's a symbol I have taken it from the web. It should be used by the teachers, whether it is an approved symbol or not. But being a teacher, I am taking the symbol for giving you. So it's not only this. This is the things which the teachers we can use. You are having separate symbol for lawyers, doctors, and so many people. And next, the names and images. Here you take the International Monetary Fund having the name and image. This is the image. It's used only by the International Monetary Fund. No one can have the right to use this particular image and the words. And you take into account of the Institute of Public Health located in Bangalore. So it is the image and the name, right? It is meant for the Institute of Public Health located in Bangalore. It's not be used by anybody else. Next. Now, what is IPR? Right? So here the rights which can be used for protecting different aspects of an invention. An invention works from multiple protection. So here many people they are inventing many things. If once a product is invented means it is the right of the person who invent. It goes to the rights goes to the person who invented. Previously, there is no awareness about the intellectual property rights, so people they won't claim any rights. But nowadays, each and everything should be claimed because it is our knowledge, it is our creation. So once we have created something, when we are not getting rights, it will be used by others. So we have to protect whatever the ideas we disseminated or whatever the ideas we created. So here it is outlined in Article 27 of the Universal Declaration of Human Rights. It comes under the human rights. With the human beings, if we create anything new, we are having the right to get right. Then the IPR are largely territorial rights except copyrights. Copyright is a global one, but you take account of all other rights it is territorial rights. Next. Here the industrial property rights relates to commercial and industrial activities. The IPR, it relates to commercial and industrial activities. When you take into account of the intangible property rights, it is connected with the intangible properties, whatever the way, intangible properties of whatever way thing you can take. Then investment property rights, they are exclusively for the protection of rights for our investment. Next, intellectual property rights. So here industrial property, we are classifying the intellectual property rights into industrial property and copyrights, the major headings. Under industrial property, 4 things are comes under industrial property and 3 things comes under the copyright. So what are the things which comes under the industrial property? So here inventions, trademarks, industrial designs, and geographical indications. All these 4 things which comes under the industrial property rights. And what are the things which comes under the copyrights? The copyrights here, the literary works or literature work, artistic works, and architectural works. All these things comes under the copyrights. Now, next slide. The history of patent in the world. 17th century BC, the food recipes are taken. This is the first thing in Italy. The food recipes are taken as patents. In 1474, in Venice, the first law on patent was introduced. In 1623, UK introduced an Act of Partnership. In 1790, US, the Patent Act was introduced, and the first patent received by Samuel Hopkins for potassium carbonate. This is the first one taken patent from US Patent Office, potassium carbonate. Then here now you can take account of the history of Indian industrial property rights. 1856 Act of Protection of Inventions. In India we have introduced 1856 the Act of Protection of Inventions. In 1948 we have implemented Trademark Protection Act. In 1957 Indian Copyright Act. In 1959 Indian Trade and Merchandise Marks Act. In 1970 Indian Patent Act. In India we have implemented the Patent Act in the year 1970. Okay, so these are some of the introductory things about the intellectual property rights. Now you take into account of the different types of intellectual property rights. At the time of giving introduction about the topic, Dr. Anthony Cruz has clearly given the different types of intellectual property rights. So here there are 7 intellectual property rights. They are patents, trademarks, industrial designs, geographical indications, copyrights, trade secrets, and plant breeders' right. These are the 7 things which comes under the intellectual property rights. So now we can see one by one. First, we've taken account the patent. So now what do you mean by patent? The right granted by the government. Patent is the right granted by the government for the invention made by a people or a person or an industry. Right? So when you are introducing or when you are creating a new things, it should be authorized by the government. When the government is giving authorization, that authorization is called a patent. So why we should take authorization from the government or rights from the government? To prevent others to use our creation or our invention, or others to sell, or others to make use of our invention. So here the patent is valid for, suppose if you people invented or created a new thing and you can approach, you can apply to the Indian Patent Office, and the Indian Patent Office granted permission and accepted your patent and given accepted your creation and given patent to you, means you can use that patent rights for 20 years. After that, if you want, you can renew it. The first patent the duration of rights will be for 20 years. Then patentable article. Suppose if you want to create or if you want to invent a thing, you have invented or you have created a thing, and now you want to approach the patent office for patent. So at that time, 3 important characteristics of your creation will be taken into account by the patent office. If you satisfy all these 3 characteristics or the features, then only the patent office or the government authorities give patent rights to you people. So what are the 3 important characteristics that we have to keep in your mind? Number 1, useful. So subject matter has useful purpose, ordinary sense of the word. Even whatever the thing, if you want to create or you have created, it should be used by even the common people or even the uneducated people or each and every individual in the society that can be used to it and get benefit out of it. If your creation fulfill the usefulness of the people, that will be accepted for patent. Then the second thing, it should be a novelty. Novelty, the second characteristic. New characteristic that is not part of the body of existing knowledge. You have to create a new thing. If you have created a already existed thing, and but at the same time, your product will be differentiated from others, and you have to explain in what way your product is differentiated from others' product, and what are the other uses compared to others' product that you have to fulfill. So the second characteristic is novelty, and the third one, non-obvious. That is sufficient differences from what has been used or described before. You have to make sufficient amount of differences between your product, that is newly created your product, and the product which is already existed in the economy or in the market, right? If you fulfill all these 3 characteristics in your creation, definitely the patent office will provide patent to you. Next. So now, why to patent an invention? Why to patent an invention? So here we have to exclusively control over our creations, right? Because it's not a simple thing to do a creative one. We have to work hard. We have to spend a lot of time, energy, money, and so many things. After that, only it is possible for us to invent or create a new one. At that time, whatever the things which is created by us, we are having the exclusive rights. So for getting patent is mostly for the exclusive rights should be in the hands of the person who created or who invented. Then prevent others from copying our invention. If we are not getting patent, our idea or our invention or our creation will be copied by others and they can use it in their own purpose. At that time, it is not possible for you to claim. It's an idea which already I have disseminated or I have created. At that time, if you are claiming, means definitely they will ask, so do you have any patent rights for this particular idea and other things? If you are having idea, means you are having the right to go to a court of law if a person who is denied to give rights to you, or if he is not giving any royalty and other things, right? If you are not having rights with you, definitely it's not possible for you to go to court of law, right? So exclusively rights which should be in the hands of the person who invented, and we have to prevent the others to use our ideas, our creation and our invention. Then commercialize. If your invention will be supposed, and mechanical engineer who is introducing a new product, if a company who is using that product, if a company is using that product, and if the company wants to use that product, if a person who invented the product, suppose a screw you take into account of, a mechanical screw is invented by a person and he got patent. Suppose that screw will be used in many industries. Suppose an industry is come forward to use your newly invented screw to produce a product in that industry. So at that time, you will get royalty or you will get some amount of money from that. That means now you are commercializing your invention. Then demonstration of talent. Here, whatever the thing you are inventing, it will demonstrate the talent which you are having. So these are the things you take into account of why we have to make a patent. Then what can be patent? What are the things we can take into for patent? So here, man-made, all man-made material things would be taken it for patent. And patent, it means the man-made things should be fulfilled the three important characteristics: usefulness, non-obvious, and novelty. If these three characteristics are fulfilled by any man-made materials, definitely that will be taken in for patent. Then process or method, any process. Suppose any method of production or any process of production, if you are invented, means that will be taken for patent. Designs, structures, in taking the of the computer science people, if they have created any software programs and other things, that will be taken it for patent. Then two grand patents here. European, there are four important offices we are having to get patent. One is the European Patent Office. The second one is US Patent Office. And the third one is Indian Patent Office. And the fourth one is World Intellectual Property Organization. These are the authorities. If you take patent from Indian Patent Office, the rights will be used only within the jurisdiction of India. If you take US, you can, that is multiple patent also we can get it. We can get for the same invention, we can get patent in India as well as in US as well as in European also. Then next slide. So here you are seeing safety pin. How many patent have got for a safety pin is 6,281 patents have received for a simple safety pin. That means these 6,280 safety pins are differ from each other. Then here you take the cricket stump. Previously, you people are witnessed immediately after the match is over, the team won the match, taken the stump and go out of the ground. But nowadays, it is not possible. Nowadays, it's not possible by the team who won the match to take the stumps with them, right? Because the cost of stumps nowadays used is 25 lakh. So here, the cricket stump, a complete set worth of 25 lakh is now used. Now the newly used stumps are used for many matches. So here, the stump was invented by Brontin Eckermann, an Australian mechanical industrial designer. He made, right? And he got patent. Without getting permission of this particular gentleman, the stems and other sets, which are the other accessories which are accompanied with the stem, are not used by cricket people who are playing crickets. So here the patent will be, the rights will be in the hands of Brontin Eckermann. So here, why are patents necessary? Why we have, what are the importance of patents? It provides incentive to individual for their creativity. So here, whatever the creativity you are having, for that you will get some income. From that you are getting some income that will induce you to think better and create more and more. So that will lead to more creation in the world, more creation in the different subjects. Then offers a material rewards. You will get material rewards. Then encourages innovation. So whenever we invent new things, then only it is possible by the people to innovate it in the field of production of goods and services, because nowadays the demand for goods and services goes on increasing. So now we have to invent new and new thing, new and new idea, new and new technology to produce goods and services. So when we invent and create new and newer, definitely that will be innovated in the field of production of goods and services. That will lead to flourish the economy or attain economic development. So here inventions and innovations make the people's life a quality one. For all these things, we need patents. Then rights of patent owners here decide who may or may not. Once you are having right of a particular creation with you means you only choose to whom the creation will be used and to whom it's not to be used. Right? That means the power is in your hand. You can give or you can transfer the power to whom that you can decide. And the second thing, how many years can use? How many years we can have the power, or how many years we can use that particular creation? That will be under the patent rights. Then the patent owner can either sell or lease. Suppose if you have created a new idea or a new technology in the field of production of goods and services of a particular product, either you can use the technology to produce the product individually, or if it is not possible for you to produce the commodity, what you have to do means you can lease it for either 1 year, 2 years, or 5 years, or 10 years, or you can give or you can sell it to somebody else for money. So at that time you will get income. So for example, the electric lighting, Edison, Swan, the sewing machine, Singer, and iPhone, Apple, and other. Next. How is patent generated? So before go for generation, before go for applying a patent, what we have to do means first we have to file a patent application. We have to what things we have invented, what are the characteristics, where we can use it, and all the description and the flow chart or diagram, whatever the things you want to give it to the patent authorities, it should be given it an application form. The application form consists of title of the invention. First, you have to give the title for your invention, then indication of its technical field, in which field your creation will be utilized or useful. Then you can the description of the descriptions are usually here. Visual materials you can give drawing, plan, diagrams, flow chart, and other things. The clients, the extent of protection. So here, first we have to apply to patent office. The application form will be in the patent office. You can download it from the website and other things. And what are the things which are asked by the patent office? For that, you have to give your opinion and other things regarding your new creation or invention. Then after that, you can submit the application to the patent office. They can scrutinize, and if you fulfill all the queries made by the patent office means definitely the patent will be granted by the patent office. So these are the things we take it for the patents. Okay. Now we take trademark. So here distinctive sign that indicates certain goods or services. For a specific product, each and every company nowadays they are having their own trademark. The trademark will be used only by that particular company, none other they can use it. So origin, the ancient time, our craftsmen reproduce their signature or marks on their artistical works. Even nowadays, you take into account a brick which is made up of a particular brick company. On that brick, you can see that the name will be made. This is the trademark. It's a sign. So in the ancient time itself, our people, our ancestors, they have used the sign on the product which they have produced. Then now it became trademark. Previously, it's a sign of mark. Nowadays, it is used. It is termed as trademark. Then it helps the consumer to identify and purchase the product. You can see a small example I can give it to you. A spade. Manvatti. Spade, which is used to dig a pond, right? So if a Tata company is making that spade, on that spade you can see that the name Tata is printed. So it is the trademark, right? So it means it depends. Suppose here the trademark motivates the purchaser, the consumer, to buy the product. When it is a quality one, definitely, even though many products are, many alternative or many substitutes are available for us, we can definitely we can select only the particular brand because the brand name is in our mind. That brand name is called the trademark. Then based on the specific characteristics and quality, the trademark depends upon the characteristics and quality of the product. Then importance of trademarks, owners have exclusive rights to use it, right? If a Tata company is producing a particular product and the name of the word Tata is printed on the particular product, it is used only by the Tata company, none other company that can use the product, use the word. Then authorize others to use them in return for payment. Suppose if any company given authorization to another company to use its trademark means after getting some amount or payment from that particular company, then after that only the original company they can allow the new company to use the trademark. Trademark can be renewed indefinitely. We can renew any number of years. Then trademark protection is legally enforced by courts to stop trademark infringement. Suppose if any people illegally using our trademark symbol or our trademark letters and other things, at that time definitely we can go for court of law against that particular. Then promote the enterprise worldwide by with the help of the trademark. Our product reaches throughout the world. Then more profit to the owners. Suppose our product will reach throughout the world. That is the minds of the consumer throughout the world means definitely there is a greater demand for our product. So at that time, the owner of the firm, they can produce more and sell it in the market. They earn more profit. Then it hinders the efforts of unfair competition. So here the trademark, it will give a unique name to a particular company. So definitely there is no, if any person who is unfairly compete with you means definitely the trademark will determine it is the original product and is the duplicate product. So definitely people, they are come forward to buy the original product. Then protect the user of similar distinctive sign to market inferior goods. So suppose the same symbol is not provided to anybody else, and if a person who use produce an inferior product and print on the trademark a particular company means definitely it will be an offense and it will take into court of law. Then facilitating international trade. Definitely, if you want to involve in international trade, definitely we should have a trademark for our product. Without trademark, the foreign buyers or foreign people, they won't accept our product. Next, so some of the trademarks things are given in the slides. You can take it here. Coca-Cola, you can see the Coca-Cola symbol, Audi car, BMW car, and by way of that, definitely used in many things. Then the holograms also used. So here the collective marks are owned by an association here, and I already told you the symbols which are used by teachers. I have shown in a particular slide, the previous slides. Now you take it for the doctors, engineers, teachers, lawyers, and accountants, etc. are having their own symbols and other things. This all comes under the trademarks. Then for what are the formalities if we go for trademark registration? Here also we have to file an application. Then clear reproduction of the sign, including colors, forms, everything. You have to clearly give what color you have used, because even the color should not be used by others. Others in the sense in the particular area. Then list of goods or services, sign should be distinctive, should be different from others, and it must neither mislead nor deceive customers. Your trademark symbol or sign should not mislead others, right? Suppose in many things we have seen in Philips tube light, the Philips company is originally producing Philips, and in some the alphabet letter symbol, that is the spelling, they have made a little change, and they are introducing a product in the market. That means it will confuse the customers or the buyers. So your trademark should not confuse anybody else. So it cannot be the same or similar to already granted. Already granted trademark symbols and other things should not be used for you. Then you take the third one, industrial design. So here, ornamental or aesthetic aspect of an article. So here, the creativity You take into account of jewels. We people are like much like of wearing jewels and other things. So different ornamental designs. That is, the ornament have different designs. So we can't imagine how many designs are available in a jewelry mart. In the same way, there are many products which are having different design and the aesthetic aspect. Then it may be a three-dimensional features or it may be a two-dimensional features. Here the industrial design, three-dimensional means shape or the surface of an article. And you take into account the two dimension, the pattern, lines and colors, etc. So it may be applicable to a wide variety of industrial product and handicrafts. So here the industrial designs are used by industrial product and the product which are produced by the handicraft peoples. So example, technical and medical instruments, then watches, jewelry and other luxury items. So here the housewares, these are some of the examples I had given: housewares, electrical appliances, vehicles, textile designs, etc. So the technical feature of the article to which it is applied are not protected by the design registration, but they protected by the pattern. Suppose here the technical feature and the industrial design, the design won't be taken into account. The technical feature will not be taken into account for industrial design. The technical feature should be go for patent rights. Then what is the need arise to protect industrial design? Here it make an article attractive and appealing at the commercial value. So if you are producing an article in an attractive way, because attracting minds of the consumer is not an easy task. And being an economic student or commerce student or management people, we have to always think about the minds of the consumer. When the consumer demand our product, when the consumer not to demand our product, that we can't predict. But the thing is, we have to attract the minds of the consumer. So the attraction should be make demand for our product. So if we create an article in an attractive manner, definitely the people, we won't think about the cost and other things. If it is a quality one and it should be an attractive one, definitely the consumers, they come forward to buy our product. So here it make the article attractive and appealing and add to commercial value and increase its marketability, right? If we produce attractable product, it will attract the minds of the consumer. That means we are commercializing and we are getting commercial value. We are getting price for our product. We are getting demand for our product. Ultimately, we can get profit. So the owner has an exclusive right against unauthorized copying or imagination by others, or imitation of by others. So it helps to ensure a fair return of investment. Definitely, the industrial designs will provide. Either you can use the industrial design for your own production, or you can sell it to somebody else. Definitely, whatever may be the way, definitely you will get an return from your investment. Then it benefits the consumers and public. If you are designing a particular product in a different way, in an artistical way, in an aesthetic way, means definitely it will be useful to public as well as the consumer, and it promotes economic development. By the handmade things are largely demanded in the international market. It is mainly because of the artistical skill and industrial designs. Then how industrial designs can be protected? How, in what way we can protect? So a registered and industrial design law, the design may be the new or original. It should be original one and it should be a new one. And we can apply for getting industrial design under industrial design law. Then no identical or very similar design. You can't make the similar design which already existed. That means you have to create a new design and a new product. Then registration certificate is issued here under the industrial design law. The certificate will be issued to the person who registered industrial design. The term protection is generally 5 years, possibility of renewal up to 15 years. So normally the industrial design under industrial design law, we will get 5 years period, but if we want, we can extend it for up to 15 years. Then the fourth one, geographical indication. Geographical indication. So here the sign used on goods that have a specific geographical origin and process qualities or a reproduction due to the place of making. So some products which are peculiarly available in some places, right? So here I give us some example also. First we will see it. So it consists of the name of the place of the origin of the goods, where the product is originated, right? Because on the origin of the origin of the product, we are giving geographical indication. Wherever you can go, the original product will be available only in the origin place, the place of origin. In some other places, in the name of others, people are producing and selling. So agriculture products typically have qualities that derive from their place, climate. That is, you take into account of the agriculture product. Maximum for agricultural products, we are giving geographical indication. So here the quality of an agriculture product is mainly depends upon the soil from which we are producing that particular product and the climate. Not all the products are cultivated in all climates. Some products are cultivated only in a particular climate. So where the climate is available, in that place only the particular product will be available, right? Okay. Here you take use of a variety of agricultural product. Example, the Tuscany, the olive oil produced in a specific area of Italy. This is the original olive oil where it is produced in Italy, the place of Tuscany, that is the original olive oil. But here many sellers, they are selling olive oil that are all not original in character. So it expands commercial activity and exports. It is simple and inexpensive and reasonable to even small and medium enterprises. They can involve and get geographical identification or indication. The place of origin may be a village or a town or a region of a country. Even from villages, many products are got geographical indications. Then we take into account of sweet spot, which is produced in Switzerland. It's an geographical indication. So here in the slide, I had given the geographical indication of Bangalore. Near about 36 products are identified and got geographical indication by the state of Bangalore. See here, the Channapata toys and Devan Holly Pomale. This is the first geographical indication received by Bangalore state. Then that is 36 products got geographical identification and indication. The products include Mysore silk, Mysore agarbatti, Nanjangoda bananas, Bayadigai chilies. So these are all the products. The product list, I had given some 4 or 5 examples only. 36 products got geographical indication by the Bangalore state. Then appellation of origin. Appellation of origin. So here it is a special kind of geographical indication used on the products that have a specific quality due to the geographical environment in which the products are produced. So here you take the Bordeaux wine produced in Bordeaux region of France. This is the best wine produced in France. Then you take Habana, tobacco grown in the Havana region of Cuba. It got geographical indication. Then you take Salem in Tamil Nadu. Salem is famous for mango fruits, Malkova Mambalam. It is only cultivated in Salem region. Then you take here the onion, Ballari onion. Nowadays we are using in our producing our food articles. It is produced in or cultivated in Andhra Pradesh, the state called Bellary. Sorry, in place called Bellary in Andhra Pradesh. Then you take into account in Virunnagar district. Our college is located in Virunnagar district. The Rajabalayam comes under the Virunnagar district. That is one of the taluk which comes under Virunnagar district. So here the Rajabalayam is famous for dogs. The Rajabalayam dogs and Chippipare dogs both are available in Virunnagar district. So these are the some of the, and the same way you can take in Tindukal biryani. Kalapakatti biryani is famous for Tindukal. And Siruvalliputtur is famous for the milk products, Palkova. In the same way, each and every region and places, they are having their own geographically indicated products. Next, copyrights. Copyrights. So here, copyrights is nothing but the protection on literary and artistic work by others and artists. So it is a very important point, topic which comes under the profession, people who involved in the professions like teachers, students, and other things. So it's very difficult for us to get a patent for our article and other things, but we can go for copyright. But nowadays, the teachers, if we are writing a book, means definitely we can join with a publisher. But normally, the copyright will be in the hands of the publisher. Nothing will be in the hands of the author. But if you are having your own publications at that time, your right, the copyright will be with you, right? So copyright means here we are protecting the literary work and artistic work of the authors and artists. So what are the beneficiaries here? Here the performers in the performance, that is actors and musicians. Here you take into account the superstar who come from Karnataka, and now he become the superstar of Tamil Nadu. The style by superstar Rajinikanth. If he wants, he can get copyright for his style. Then the producers of phonograms in their sound recording, and the broadcasting organization in the radio and television programs, all these things they can get copyright. It will not be used by others if they are using or without getting permission. If they are using, means definitely it is an offense. Then what are the works covered under copyrights? Novels, writing poems, plays, that is stories, reference works, newspapers, work, advertisement, computer programs, database, films, and musical compositions, painting, drawing, photographs, sculpture, architectures, map, technical drawings, etc. All these things which comes under the copyrights. So now the duration available here according to WIPO is not less than 50 years after the creator's death. The death of the creator, 50 years we are having copyright with the person. That means their legal heirs, they can use that copyright. Then national laws, both creators and their heirs, legal heirs and successors to benefit financially for reasonable period of time, normally 50 years. For Indian national law, if you get Indian copyright, you can use the copyright for 50 years. Even after that, your legal heirs and your successors, they can use it the copyright. Then laws can be enforced by right holders. So here the civil action suits, administrative remedies, and criminal prosecutions, injunctions, orders requiring destruction of infringing items, inspection orders, and other things. Then benefits. So here it fosters the human creativity and innovation. So the right will motivate the people to create more and more things. Then incentive in the form of recognition and fair economic reward, right? Suppose if you are publishing a books with a reputed publisher, the publisher will give a reward to the author, right? So individual and companies can more easily invest in the creation and development. Then it helps to increase access and enhance the enjoyment of culture, knowledge, and entertainment. So here you can take into account the literary articles. Definitely, it will reflect the culture of a particular country or a particular people and other things. So definitely, we have to make our literary work under copyrights and other things. Then regulation rather is not necessary if need be. Then trade secrets. So normally a trade secret will not be revealed as it should not be given to others because it is a trade secret. The word itself, you have to maintain secret. Suppose a pharmaceutical company, if they take into account Ranbaxy is producing a medicine, in what proportion they are mixing the raw material, it will not be openly given to others. So it's a trade secret, but even though the trade secret will be get it rights. So here any confidential business information which provides an enterprise competitive edge may be considered trade secrets. So here confidential business information. The business information should be confidential, because if you reveal your confidence, that means your business technique to others means others make use of the technique and they can make profit out of it. So here the confidential work comes under business information. It should be kept secret, and for that also you can get rights. The trade secret encompasses manufacturing or industrial secrets and commercial secret. It consists of both manufacturing or industrial secrets or commercial secrets. The unauthorized use of such informations by persons other than the holder is regarded as an unfair practice. Definitely, the person who is having trade secret rights, he can go for court of law. So here, the trade secrets includes sales methods. What type of sales technique you are following to sell your product? Then the distribution method, even the consumer profiles, the consumer profile which you are having, it should be kept a secret with you, because if you reveal this means definitely your the rival firms, they can make use of your information and they can capture some of the customers from you and they can sell their product. Then here you take clients and manufacturing process and other things. So all these things comes under the trade secrets. So it requires reasonable effort to maintain secrecy. But suppose you take into account of the recipe of Coca-Cola, no one can find the recipe of Coca-Cola. Not only Coca-Cola, and almost all the beverages. What is the recipe they are following? That will not be revealed to anybody. Then algorithms used by the Google search. Then recipe of Talapakatti biryani. I have already told you, Talapakatti biryani is the geographical indication or identification received by technical areas. Here, what is the recipe they are using to prepare the biryani? That will not be revealed to anybody today. So it comes under trade secrets. Then the medical formula used by Ranbaxy and other medical pharmaceutical companies. Then here it is of two types. The trade secret is of two types. One is positive and negative. Under positive, what to do by the competitor, and negative, what not to do. In both ways, we can get trade secrets. Then how long the trade secret lasts? Here, potentially forever. We can use it forever. It is lifelong. However, it exists as long as the secret is maintained. And if you broadcast it to the world, you are out of line. So suppose if anybody, if you leak out your secret to anybody else, means definitely you are out of line. Then registration under protection. So registration, no way to file a registered trade secret. Under protection here, employ multiple means of security, physical security for documents and prototypes. Don't talk about your secrecy with others. Then confidentiality agreements with the employees and third parties, etc. Then potential trade secret, technical and scientific information, financial, even legal, and even HR information will be come under trade secrets and commercial information. Then next, sir, can I take 5 minutes more? And the Guru sir?
Professor, yes, yes, Professor.
Can I take 5 minutes more?
Yeah, if you want to take 5 minutes, you can
Okay,
take,
sir. Okay,
Professor.
sir. Just 5 minutes.
Conclude
Within 5 minutes, I can close it. Then here.
Okay, Professor. Thank you.
Okay, sir. Okay. The advantages and other things. And the last one, you take the plant breeders' rights. Even now, the people who plant, that is the people who are doing nursery services also, they are having the rights to take the plant breeders' rights. Here, it allows plant breeders to protect new varieties of plants. It includes seed, cuttings, divisions, and tissue culture and other things. In olden days, our farmers, after harvesting the product, whatever be the product they are harvesting, after harvesting product, a portion of the product will be taken for seeding for the next season. But nowadays, that culture will be removed from the society. No farmers are now, they won't come forward to follow that practice which the old farmers, that is the ancient farmers, they have followed. Now now our farmers immediately after harvesting the product, they are selling the commodity in the market, and for the next season they depend upon the corporate companies to get the seed from the corporate companies and other things. So now the plant breeders, they are having their own rights. If you introduce a new cross breeding, nowadays there are many cross breeding or high yielding variety seeds are introduced with agriculture and other things. If the things are available, you can get rights for that. So that comes under plant breeders' rights and other things. Then I had given the fee structure, patent fee structure for natural person and other persons and other things. So this is once if you want to apply it to apply for patent rights and other things, at that time you can make use of this. Then for taking over the copyright and trademarks, for online registration, we have to pay a fee of rupees 4,500, and for other cases, 9,000 rupees we have to pay. Okay, thank you for the passion listening. It's an introduction about the intellectual property rights. I think you people understand what is industrial rights, intellectual property rights and other things. So nowadays, there should be a need arise to create. Right. So in this way only, this national webinar was organized, and I had given, even though I had the way of rush, because I have to consolidate my lecture within that particular stipulated time. I have rushed up and I had given some information to you. I think it will be, I hope it will be useful to you. Thank you for the opportunity given. Thank you. Sir.
Thank you so much, sir, for giving your valuable insights on intellectual property rights. So, with that, we will go ahead and take some time for questions.
Yes. Is any queries and doubts? You can ask.
Hello.
Yes.
Hello, audience and students. Now, I request now students and audience to come forward to get a clarification of your doubts. Because now, when professor has delivered a lecture on IPR, professor has focused plethoric explanation of various components which are falling under IPR. And now really professor was bombarding with so many concepts which falls under IPR. Therefore, I feel that when audience you raise questions, you will get more clarifications from the professor. Now, please, audience, now it's time to get your questions to be clarified.
Anthony Cruz, sir. Sir.
Sir, I feel that there is no any questions
Okay,
from
sir.
audience. It seems.
I will share an
But,
information to you.
Okay, sir.
Whether it be applicable to Karnataka state, that I don't know.
Okay, sir.
In Tamil Nadu, the patent office, Indian patent office located at Chennai.
Okay.
They are organizing an awareness program
Okay. Okay.
to all the college students
Okay.
regarding IBR on online mode.
Okay. Okay.
Okay, I will give the information to you. If you want, you
Okay,
can
sir.
organize. Uh,
Uh-huh.
you can organize this type of program for all the
Okay.
students of your campus. Not only your campus,
Oh,
your sister concern also you can use it.
okay. Okay, sir. Okay, sir. Definitely.
Okay, sir.
Definitely,
Okay.
sir. Okay. Thank you.
If
Thank
there
you
is
so much.
no queries and questions, kindly you can wind up, sir.
Yeah. Oh, yes, sir.
Okay.
Sir, see, since question now did not come from the audience, it
Okay.
shows that the deliverance given by the professor was very elaborative, and it was giving a clear idea to the audience. So since there is no questions, now I'm closing this question session, and now I request the student who is executing master of ceremony can go ahead with feedback session. It seems. Am I right? Now it's over to the person or a student who is doing master of ceremony.
It looks like we have covered all our questions. Thank you, sir. Now I call Preeti from final year MCOM for the vote of thanks.
Good afternoon to
Postpone.
each one gathered here on this wonderful afternoon. I would like to propose the vote of thanks. On behalf of the college, I, Preeti, from final year MCOM, take this opportunity to thank our respected guest speaker, Dr. S. Ganesan sir, for not only sparing his invaluable time for us to grace this occasion, but also for illuminating us with commendable talk on the subject. Thank you, sir, for clearing the concept and enhancing our understanding pertaining to the intellectual property right. You have put best of your efforts to make this event an unforgettable one. Thank you, sir.
Thank you.
I extend my gratitude to our respected principal madam, Dr. Rekha Sethi. And I would like to thank our head of the PG department, Dr. Anthony Cruz Tangaraj, for organizing this webinar. I also express my gratitude to all the faculty members and all the participants present in this meet. I sincerely thank the technical members for the support. Once again, I thank one and all wholeheartedly. Thank you.
Thank you so much, Preeti. Dear participants, we have shared a feedback link in the chat box. Kindly fill the feedback form to get your certificates. Thank you so much, sir, for your presentation. Thank you all for your participation in today's webinar. Thank you once again for everyone. We appreciate you being here. Thanks again for joining us. Thank you.
Thank you, sir. Anthony Guru, sir.
Professor, Professor, thank you so much. Yes,
Ah,
sir. Yes, sir. No, thank you,
thank
sir.
you very much. Can I leave?
Thank you so much. So you have spent your valuable time, and happy about your contribution to the lecture. Thank you so much, sir. Thank you so much.
Okay, sir. Thank you. Thank
I'll
you.
call you
I
back,
take leave.
Professor.
Okay, sir.
Thank you.
Thank you. Okay.
Bye bye. Bye bye. Thank you. Thank you so much.